Hi, I'm attorney Vincent Davis, and I've been fighting CPS for over 35 years. Through my years of experience, I've gained invaluable insights that I'm ready to share with you. If you're a parent or a caregiver or a relative, we need to talk. I'm offering a new opportunity for you to speak with me on a one-on-one basis. Ask me any questions, and I'll provide you with the insight you need to take steps in your CPS case. Members get everything they need to gain confidence and the knowledge that they need to support necessary to truly fight back. And as a special thank you for attending, I have a special offer just for you. Don't miss out, join us, and let's take that next step together. I'll see you at the question and answer event. Okay, good evening. How are you?
Great, how are you?
This is Savannah.
Yes.
Savannah, what city and state are you in?
I'm in Ridgecrest, California.
What county is that?
Kern.
Okay, you're in Kern, so your case was in Bakersfield?
Yeah.
Okay, been in that court several times. So, what's
Oh.
going on? What questions did you have for me for tonight's office hours?
So I guess I'm a little stuck on my appeal. I guess I don't really know how to put my questions together, but I'm just having a hard time with getting my briefing together because like the word count that they require, but also because I really don't think that the paperwork that they're sending me is matching up with what they're sending the appellate court, because I've asked the appellate court to augment the record for the missing warrant that's not in the paperwork that they sent me, and the appellate court tries to tell me that they pretty much it's in the record that they have, but it's not in the record that I have. So I don't really know how to go about that, or if I should even attempt to make the argument if I don't have it in the record that they're sending me, if that makes sense.
It does, but here's the problem. Why are you trying to do your own appeal?
So when I had appealed it, and the problem with the timeline in my appeals.
Savannah, I ask you a question.
Sorry. Sorry.
Why are you trying to do a complicated, sophisticated CPS appeal?
Because my appellate attorney's briefing didn't address anything that I wanted to address, or like the whole point as to why I was even appealing it.
Did your appellate attorneys tell you that there were no issues and they wouldn't do an appeal?
No, he gave a briefing.
Oh, so
He
he already turned in the briefing?
Yeah, I had asked them if they could relieve him so I could submit my own briefing,
See,
since.
that's not a good strategy, Savannah.
Yeah, I guess.
Okay. Now, I don't know who your appellate attorney is, and I don't want to know the name. However, I know that court appointed appellate attorneys in your district go through the vetting process. They're usually very experienced attorneys, and they either do the appeal on their own or they're supervised by a special group of lawyers that take care of court appointed appeals. So, for you to say they're not doing what you want is means to me that you are going down the wrong road.
I get what you're saying though.
Have you ever seen a video on my YouTube channel called What is Justice?
No, I have not.
Okay. So after this conversation, I want you to go to my YouTube channel. I want you to type in what is justice, and you'll see a video of me standing in front of a whiteboard explaining something to some clients. They actually took this video. I didn't take it. They asked me, could they tape this meeting we had? And I said, yes. And it turned out to be a really good video. And they said, hey, you should post this on your YouTube channel. So I did. So let me tell you in summation what the video's about, okay?
Okay.
What is justice to you? To you, it's probably what you believe is fair, what people have told you, and what your sense of right and wrong since the time you were born. Okay. That's your sense of justice. It's in your heart. Okay. Make sense?
Yes.
Real justice are things based upon the law, the statutes, the case law, the Constitution, the code of evidence, the rules of court. Now, there is a slight overlap between what you think justice is and what justice really is. It's about 5%. But by definition, that means you're about 95% incorrect. Okay? And
Okay.
most of the time, people and their attorneys, like your attorney, argue about what is justice and what should go in an appellate brief or in the defense of a trial. Okay? Because you have a different sense of justice than what your court appointed attorney has. Right? And what happens is that time is spent, the attorney trying to pull you to understand his or her sense of justice, and you trying to pull the attorney the other way, trying to get to understand your sense of justice. Okay. Now, if you want to win instead of being right, if you want to win because they're different, you will probably take the advice of the appellate attorney. As I said, because many years ago, 20 years ago, I used to do that work. Court appointed appellate attorneys are actually vetted by the Court of Appeals. So you could get, the chances of you getting a incompetent court appointed attorney at the appellate level is very slim. You have to
Okay.
assume that these people are experts.
Right.
And if some appellate attorney tells you, hey, Savannah, you know, you should argue and we should brief items A, B, C, and you say, no, I think we should do X, Y, Z, don't do that. You're going to end up losing. Okay. Now, are court appointed appellate attorneys ever wrong? Yes. But the percentage is much smaller than you might believe. Okay. So I don't know anything about your case, but I don't need to. I just know, number one, you're not a CPS appellate attorney, and the person that's been assigned to you is, and they've been vetted by the Court of Appeals.
Okay.
Okay. Have some faith in the process. All right. You might want to appeal things that are just dead bang losers. All right. And you're calling me, which is fine. That's why I do these office hours, and you're asking me a question that is really a waste of your time. You asked me about the word count and formatting. That's not going to win a brief for you. Okay?
Yeah.
All right. It's important, but it's not dispositive, meaning you're not going to lose your kid because you didn't format or you did the wrong word count. Okay, that's not how usually how courts of appeals operate. All right. You have to focus on what the substantive law is and what the substantive legal arguments are. And if I ask you, hey, Savannah, what are the three biggest appellate issues in your case? I would bet $1 that you wouldn't be able to tell me because that's not your expertise. I always give this example. Savannah, I'm a pretty smart guy, but my auto mechanic told me I needed a new transmission. Guess what I didn't do? I didn't get on Google and try to figure it out. I didn't go to Pet Boys and buy the Shilton book on 2017 BMWs. I didn't go buy supplies for the transmission. I didn't go buy the tools to change my transmission. Okay, I didn't do that. You know why? I don't know how to do that. And it's no sense in me trying to fool myself that I can do it. Likewise, you shouldn't try to fool yourself that you know how to do it. Now, if you tell me, hey, Davis, I went to law school, I've done cases before, I have experience in doing appellate opening briefs, okay, I'm wrong. Pardon me. But unless you're going to tell me that, stop it. Okay? Quit spinning your wheels. You know, when I was growing up as a kid, they used to have these hamsters in these big glass aquariums. And in the aquarium, there was this little wheel. And you get the hamster, and the hamster would run and run and run and run. But the hamster wouldn't go anyplace. That's what you're doing. You're that hamster running and running and running and running and not going anyplace. Don't waste your time on it. Focus on doing what's necessary to get the children back. Win or lose the appeal, I'm going to assume that your case is still going to go forward. And there are things that you can do to get your children back.
The next hearing is the adoption.
Okay. Have your rights been terminated?
No.
Okay. So the next hearing is not the adoption hearing. This is the way it works in California, okay? It's a very simple 5-6 step module, okay? Number 1, detention hearing. Number 2, jurisdiction hearing. Number 3, disposition hearing. If you lose the disposition hearing, there's a 6-month review, a 12-month review, and maybe an 18-month review. And in rare cases, a 24-month review. If you don't get the children back after one of those reviews, they have something called a selection and implementation hearing, otherwise known as the .26 hearing, where they can terminate your rights. If you go to that hearing and they terminate your rights, not your reunification services, but they terminate your rights, once that's done, the next hearing is the adoption hearing. Okay, so if your rights haven't been terminated, there's 101 things you can do to get your children back. Let me ask you this. Have they terminated your reunification services?
Yes.
Okay. They've terminated your reunification services and they have
limited my rights.
They have not terminated your rights.
No, but they've limited them.
Okay, and that's normal. So the appeal that you're doing actually isn't an appeal, it's a writ. It's a special writ that you have to do when your reunification services have been terminated. Okay. Now, between now and the next court date, say you lose that writ. There are many things that you can do to get your kids back. And I don't know if you have a court-appointed attorney or a private attorney, him or her, you need to speak to come up with a plan, a strategy to get your kids back. Because you can get your kids back up until your rights are terminated. And I'll tell you something that I didn't used to tell people, but I do now because I've seen it happen twice. You can get your kids back after your rights are terminated. You know, a lot of people say, oh, that's irresponsible to tell people that. Because it doesn't always happen. But I have seen 2 incidences of that happening. One woman got her kids back after they were adopted by someone, and she lost her rights. 5 years go by. The kids are adopted and living with the adoptive parents. This case is out of San Diego.
Okay.
And the reason why I know about it is because the lady called me and asked me to help her. And I said, I can't help you. She said, well, is there anybody that you don't know that might be able to help me? I said, yeah, I have a friend. His name is blah, blah, blah. Call him up. She called him up. And the 3 of us would talk periodically. She got her kids back. Okay. Her kid, she had lost her rights for 5 years. And the kid was actually adopted by someone. She got the kid back. Now, the stars had to align the right way.
Right.
Don't get me wrong. Okay. But I digress. The bottom line is let the appellate attorney handle your writ. By the way, in California, writs are not handled by court-appointed appellate attorneys. They're supposed to be handled by your trial attorney.
Yeah, so the writ is that's a whole different appeal. I have multiple appeals going on right now, and I got so the I got three of them consolidated together, and then the first two were the ones my appellate attorney gave the briefing for, and they didn't strike. They relieved him, but they didn't strike out his briefing. They just allowing me to submit a supplemental briefing. So the writ petition, that one is the last hearing that I just appealed that we just had, and that's my newest appeal that I have. And my attorney actually sent me I just got all my paperwork in the mail the other day, so that way I could because she told me she wouldn't write up my writ petition, but I told her I would do it myself.
That's like you're trying to change transmission in my car,
I'm
right?
not.
Let's be honest. Let's be honest. Do you know how to do a writ?
I know enough. I mean, I'm not in law school, but I am taking classes for law. I grew up around law enforcement. So, I mean, a lot of my briefing has to do with ineffective assistance of counsel, the Fourth Amendment due process and due
Okay.
process.
Now, let me ask you something. Let me give you a little test. Do you know what you have to do to prove ineffective assistance of counsel?
I do. I mean, I can't
What?
tell you off
What?
top, but I do.
Okay.
I got it in my briefing. I
Okay.
know, I know there has to be a, oh my God, I'm so bad with communication.
No, that's all right. Hey, you know what? Hold on a second. All right. I want you to stay on the screen. I'm going to be back in 2 minutes. I'm going to go grab something. Okay.
Okay.
All right, Savannah, you there?
Yeah.
I went to find a brief that I did on the ineffective assistance of counsel.
Okay.
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 I'm going to find it and I'm going to email it to you to use as a template.
Okay.
The names will be removed because that is confidential.
Right.
Okay. But I'm going to give you some guidance so that you can have a chance of arguing that the right way. Okay.
Okay. Thank you.
Grace told me that you had some questions for me.
I
Let's
know
not.
I meant to get a whole list of questions. My head didn't even I I didn't even think it through this interview because I had assumed that it was for Bob Pace. I don't know. My brain goes other ways sometimes, and I just should have spent the whole time putting questions on a piece of paper is what I meant to do, but that was my bad. I the only thing I've been concerned about is getting my briefing in, but they keep rejecting it because of the word count, and I can't seem to get my point across if I take out any more words because the time. I mean, I'm trying to fit almost 11 months of issues in a piece of on 35 pieces of paper, and they just granted my they just granted in part from my request to submit an oversized briefing, but they only said it had to be 28,000 words, and my briefing's like pushing 80. I mean, I'm trying to argue it all the way back to from the removal in the investigation to now, and we're going on a year right now.
Okay. Can I I'm trying to find a nice way to say this. You know, one of the viewers, Juvie World, said, "You'll get your kids back, girl. Keep going."
Thank you.
Yeah, that's what one of the viewers said.
Thank you.
Um, I agree with that, except for if you don't do it the right way, you're not going to win. You're not going to get your kids back.
Right.
Okay.
I've spent the
So
last 11 months working on it. So
I'm gonna tell you something that maybe nobody's told you before. The writ that you're doing has to focus on the last 6 months of the case.
yes, I know this.
So when you tell me I'm gone all the way back to the beginning and arguing the detention,
Yeah.
that's beyond the 6 month limit, and I don't know why you're doing that.
So the writ petition, my questions weren't based on my briefing for my writ petition. I haven't even attempted to work on that yet. My questions are based off my original appeals that are ongoing right now because I have like 7 different appeals going and 3 of them consolidated together.
Okay, I have never heard of such a thing.
Yeah.
Savannah.
Yeah, well, the time, that's what I was saying. The timeline in between all of my hearings is just absolutely ridiculous. It's ridiculous. That's one of my arguments in my briefing is them exceeding past its statutory time frame for the detention and the jurisdictional hearing. They've had months in between all my hearings. And I couldn't even appeal any of it until disposition and that wasn't even until 6 months into my dependency proceedings.
May I ask why they took the kids away from you?
Yeah, so they took them because of mental health and just past substance use that I used to do. But that was a long before my pregnancy. I've gotten my life together since my
Do you
son.
have do you have a mental health diagnosis?
Yes, and that is what they've built almost. That is their entire argument this entire time. That's literally the only thing they've been using, and the only thing the judge stated at the detention and the jurisdictional hearing. That's why that they kept my kid detained was because I had a mental health disorder.
You seem fine to me. What's the disorder?
Bipolar disorder.
You on medication?
Yeah,
Are you going to counseling
I see my therapist every 3 weeks, or not my therapist, my psychiatrist.
to check your blood levels on the drugs?
Who CPS?
No, the psychiatrist.
Oh no, the psychiatrist isn't even. I don't even think she's aware of those issues that I used to have.
Is there or did your therapist or your psychiatrist come to court and testify?
No,
Well, that's why you lost. How come your attorney didn't bring your psychiatrist to the court to testify?
this is my argument for the ineffective assistance of counsel because my attorney never allowed me to contest the allegations, never allowed me to present evidence or call my witnesses, ever. And as a matter of fact, the detention hearing, I didn't realize that's what he had done until I read the transcripts, and I put two and two together. But he had actually waived my rights to be able to contest the allegations, and it waived further. He said further of advising me of my rights, and
We,
just
you know what? If you're telling me the truth, you do have a great ineffective assistance argument, and you need to make sure that's done. Why wouldn't your oh well, he's not going to argue that he was ineffective assistance in the brief that he's doing, right?
So I had there is the only thing that I submitted two complaints on him, one before the jurisdiction and then one after the jurisdiction, stating, at the detention hearing, he had told me that I wasn't allowed to I brought evidence and he literally pushed it away from me. And I put it on the complaint that he told me I wasn't allowed to call witnesses or contest the allegations until the next hearing. And then I did another one after the jurisdictional hearing because he told me because of preponderance evidence, there was no point on contesting anything. And then in between that time frame, there was an ex parte hearing where my mom is what this case is built off of. She's lying to take my kid. And there was an ex parte hearing that she lied and said things were going on at my son's medical appointments that weren't happening. And my rights were limited at this hearing that I had no knowledge of, that my attorney admitted at the Marsden hearing he never told me about. And they allowed them to submit, I think her statement says some kind of proof, just proof. I forget the wording that they used. They submitted the evidence that she said her testimony as evidence without allowing me to have any say in any of it. It was all completely lies. And I testified that at the jurisdictional hearing, and nobody took light to that.
Did you file a state bar complaint?
Yes, I did. I did file a state bar complaint on him, and they closed it because they said that even though it's not, they said even though that it's because my complaint was that I had asked him in emails, the day after the detention hearing to have a rehearing and appeal it and stuff like that, and he told me that there was no point in doing it, and I told the bar association that, but they said the only thing that they said was pretty much even though it is a requirement for him to have to get a hold of me and fight my case, that the attorneys have the right to do it the way that they pretty much want to do it because their advice is better than what I think I want to do, which is what they've been telling the court. All the courts tell me at the Marsden hearings. I've had 2 Marsden hearings. I've gone through 5 different attorneys at this court,
Yeah.
and it's completely, I finally have an attorney now who helps me, and it's just difficult because I'm always reiterating back to the beginning issues, because that's pretty much what all this is stemming from, and they're painting me as a danger to my kid because I'm bipolar, and they're going off of all the testimony that they allow my mother to have, but I'm not allowed to cross-examine her. My attorney doesn't cross-examine her. They just take her testimony and admit it into evidence as facts. So it's been difficult.
It sounds like a mess.
Oh yeah, absolute mess. Yeah, it's ridiculous. And my attorney actually gave me, so the first complaint ended up in a hearing. I guess I got the minute order in the mail for it, where the judge decided that she didn't find that he had lacked in his duty of presenting me. And then the second one, where the second complaint, is when I ended up having the Marsden hearing. So at the Marsden hearing, he gave me his response on paper that he had towards my complaint, my second complaint. And he pretty much he stated that I wanted to call my brother. Well, there was multiple people I wanted to call, but he stated in there, I told him I wanted to call my brother up as a witness, but he felt in his opinion, and he still felt in his opinion, that it was not going to have any weight on the judge's final determination, which is why he didn't say the words, didn't let me do it, but that's why he didn't call him up as a witness. And he was just trying to say I was hyper focused on little things that had nothing to do with what the judge took jurisdiction over my son for the jurisdictional hearing, but exactly why I wanted my brother to testify or call him up and cross-examine him and my mother, who was, on the phone for that proceeding, was because my son's attorney had tried to say that there was evidence in the report stating that I wasn't taking my medication. And I had actually gotten the attention of my attorney before she took jurisdiction during this hearing, because the bailiff seen me trying to like kind of, whisper to him, because I don't want to be rude, but I was trying to get his attention. And I told him this is why I wanted to bring my brother up, because in the detention report, it was my mom who said it was my brother that told her I told him I wasn't taking my medication. And he was like, he nodded when I told him, and he went and sat back down as everybody else gave their reasons why for taking jurisdiction. He didn't say anything.
Well, generally, to prove ineffective assistance of counsel in California, you're going to have to show that the lawyer's performance fell below an objective standard of reasonableness and that this prejudiced your case.
Right.
So specifically, you have to show three things. The performance of the attorney was deficient.
Mm-hmm.
In other words, the lawyer's performance was not competent or professional.
Right.
The second thing you have to show is the performance prejudiced you as a parent in the case. The lawyer's mistakes or failures led to negative outcomes in the case.
Mm-hmm.
And the third thing you have to prove is reasonable probability. Hold on a second. My phone's going off in the courtroom. The third thing you have to show is the reasonable probability of a different outcome. Okay, and this is where a lot of people fall down in their ineffective assistance of counsel brief. You have to show the court that there is a reasonable chance that the outcome of the case would have been different if the lawyer had performed competently.
Right.
Okay, that's where you're going to need some help. You're going to need to talk to a lawyer, because you're going to have to show the court that your case would have turned out differently had you called witnesses or had he made objections, right?
Right.
So in a nutshell, that's what you need to do to perform or to show ineffective assistance.
Okay.
All right. Hey, Savannah, this is what I want you to do. We've come to the end of the office hours for this evening. I want you to get your questions written down.
Okay.
Type them out.
Okay.
Send them to Grace. We're going to have you back on the show, and you're going to ask me some real questions, okay? And you're going to be organized.
Thank you.
All right?
Okay.
All righty. And as an appreciation for coming on and sharing with us, and hoping using your situation as a learning tool, I want to offer you a free 1-hour consultation. If you send me the paperwork, I'll review it, and I'll give you some pointers to help you on your writ, because that's going to be an important thing. And if you want, I can review the minute orders and the reports and come up with a strategy for you to get your child back. It's a strategy, though, that you're going to have to follow. And I can tell you right now that some of the things you won't like.
Right.
Okay. Now, remember, I'm only trying to win a case that's going down the wrong hole right now. So some of the things are going to be drastic, what I'm going to tell you to do. But you can do them. The only question is, will you? Okay?
Okay.
So get those questions together, get them to Grace, my producer, and we're going to have you back on the show. Thanks again, Savannah, for being on. Okay?
Thank you.
All right. All right, everybody. Thank you for watching. This is the end of office hours for this evening. I'm going to end the stream now. Oh, we have an outro to play.
Hi, I'm attorney Vincent Davis, and I've been fighting CPS for over 35 years. Through my years of experience, I've gained invaluable insights that I'm ready to share with you. If you're a parent or a caregiver or a relative, we need to talk. I'm offering a new opportunity for you to speak with me on a one-on-one basis. Ask me any questions, and I'll provide you with the insight you need to take steps in your CPS case. Members get everything they need to gain confidence and the knowledge that they need to support necessary to truly fight back. And as a special thank you for attending, I have a special offer just for you. Don't miss out. Join us, and let's take that next step together. I'll see you at the question and answer event.